according to law. God save the United States and this honorable court.
Good afternoon. Thank you for attending this Zoom hearing. I am very sorry that we weren't able to accommodate you in New Orleans this week. As it turns out, one panel of our court is having some arguments, but since you were the only panel on which both attorneys signaled your willingness to show up, we didn't think it made sense for us all to troop down there for that purpose. But things are going to change pretty soon, I think. So that's something. We do have a couple of adjustments or extra rules of the road for purposes of Zoom hearings. One is we ask you to silence any other devices you have or those of people in the room with you. Second one is that we still do the audio recordings of the sitting, but we will not, as in New Orleans, you're not allowed to video or audio them for yourselves. If you like, we will give you 5 minutes uninterrupted time at the beginning of your presentation, just because there's always a little bit of a gap in communication here. And then the other thing I would say is we will appreciate in both of your cases record citations. We have a time clock system. The yellow light will tell you that you have 2 minutes left, and when the red light signals, we ask you to conclude unless you're answering a question from the court. The sole case this afternoon is number 220416, Polyflow versus Spclt RTP, and we'll hear from Mrs. Stratton to begin.
Thank you, Judge Jones, and may it please the court. The parties' contract says that any action arising out of the agreement must be arbitrated. In this action, Polyflow alleges that appellees breached the agreement, giving rise to various contract and tort claims. But the district court denied Polyflow's arbitration request. This court should reverse for 2 reasons. First, because the parties undisputedly have an arbitration agreement, the law heavily presumes that Polyflow's action is arbitrable. To deny arbitration, this court must have positive assurance that the arbitration agreement cannot be read to cover this action. There is at least no such positive assurance here. Second, appellees' merits defenses and procedural arbitrability challenge are for the arbitrator to decide, and thus may not preclude arbitration. To begin, the scope of the arbitration agreement here is reasonably construed to cover this entire action. The settlement agreement requires arbitration of any action that arises out of the agreement. The plain meaning of action is lawsuit, the entire civil proceeding. So the parties agreed to arbitrate the entire civil proceeding if it arises out of the settlement agreement, and this lawsuit qualifies. First, this lawsuit exists because of the settlement agreement, and the first page of Polyflow's complaint at 1189 of the record on appeal makes that clear, stating that Polyflow is bringing this action because the parties entered a settlement agreement, but appellees have not complied with it and never intended to comply. Second, this lawsuit includes claims that appellees concede arise out of the agreement, specifically Polyflow's claim and appellee's counterclaim for breach of the agreement. So because this action unequivocally includes claims that arise out of the settlement agreement, and indeed the lawsuit only exists because there is a settlement agreement that we allege has been breached, the action arises out of the agreement. And the plain language of the arbitration clause thus requires arbitration of the entire lawsuit. And this court employed that reasoning in its 2019 decision in Archer, which we've cited to the court as supplemental authority. The Archer panel focused on the plain meaning of the term action, which meant the entire lawsuit, not just individually qualifying claims. And it refused to rewrite the arbitration agreement there to encompass only individually qualifying claims. And I think it's important to note that the reasoning that Archer used applies with even more force in this case, because there, Archer involved an exclusion from arbitration. So the plain meaning of action, the exclusionary language, had to be enough to overcome a presumption in favor of arbitration. Here, the plain meaning of any action governs what is included in arbitration. So in this case, the contract's plain language and the presumption in favor of arbitration are rowing in the same direction. Now, appellees have contended that the settlement agreement deviates from the plain meaning of action and specially defines action to more narrowly mean only claim. But the contract does not support that argument. You can see the settlement agreement at tab 4 of our record excerpts. And if you look in subsection A on the very first page, you'll see that the settlement agreement does not define the term action. So under ordinary contract interpretation principles, the plain language of the term should govern lawsuit, entire civil proceeding. What the settlement agreement does define at A1 is the term claim. And it defines it because it's going to use that term to describe what is being released by the parties in this settlement agreement and released. So it defines claim expansively to include not only claims, but also demands, actions, causes of action, so on and so forth. All that this means, however, is that when the settlement agreement uses the word claim, it means to incorporate a more expansive meaning. It does not mean that when the settlement agreement uses the word action, as it does in this arbitration agreement, that the parties intended to more narrowly constrict the plain meaning of that term to mean only claim. And in fact, Your Honors, A1 of the settlement agreement that defines claim shows the parties understood that there is a difference between the word action and the word claim because they define claims to include claims, actions, and causes of action, showing that they understand the difference. So we contend, with the support of Archer and other authorities, that this any action clause is unambiguous and the entire lawsuit must be arbitrated. But that is at least a reasonable interpretation of the arbitration agreement. And so in that case, the standard for denying arbitration is not met because this court can have no positive assurance that this agreement is incapable of being read to cover this action. I'd like to turn now, unless the court has questions about the scope of the arbitration clause, to appellees' asserted defenses.
Let me ask you one question. When you say arbitration clause, the settlement agreement has 2 paragraphs discussing arbitration. Are you referring to B5C or C4, or how are we supposed to interpret those provisions together?
C4 is the clause that I'm referring to. And Polyflow's position is that based on the text and context of the settlement agreement, that C4 is the arbitration clause. B5C is essentially belt and suspenders. It's additional language that also underscores the broad intent of the parties to arbitrate a broad range of disputes. And so when I am referring to the arbitration agreement, I'm referring to C4, but B5C, as we've argued in our brief, is further support for the argument that there's no positive assurance that the parties agreed to exclude any of the claims in this action.
Okay, thanks.
I'll turn now to defenses. This court should hold that the issues of release, prior material breach, and lack of mediation are for the arbitrator to decide. This court's inquiry, when faced with a request for arbitration, is very limited. The court does not address the merits, but asks only whether an arbitration agreement exists and whether the subject matter of the dispute is within its scope. Where the existence of the contract is not at issue, as here, the only defenses a court may consider are those that specifically relate to the making of the arbitration agreement itself. Defenses that apply to the continuing enforcement of the contract as a whole are for the arbitrator to decide as part of the merits of the underlying dispute. This court has held that repeatedly in Primerica, in Bank One, in Will Drill, and the Supreme Court has held the same in Prima Paint. Here, appellees' defenses that Polyflow has sued on released claims or that Polyflow has committed a prior material breach of the settlement agreement by firing the neutral pipe expert, these are not independent attacks that solely relate to the arbitration agreement, but they are merits defenses that go to the enforcement of the contract more generally. And Appellee's answer illustrates that. Their answer in the district court, which this court can find at Record on Appeal 1324 to 1325, and I direct the court specifically to paragraphs 3 and 15, make it clear that they have pled both release and prior material breach as affirmative defenses to Polyflow's claims on the merits, as well as using both release and prior material breach in the form of allegedly firing the neutral pipe expert as a basis for their counterclaim for breach of contract. So it's clear from their answer that these issues, release and prior material breach, these are merits issues for the arbitrator and not defenses to the making of the arbitration agreement for the court.
Ms. Stratton, so let me move back to your first issue for a minute. Let's assume there's a textual argument in the arbitration clauses for looking at this, your complaint, or looking through to your causes of action or whatever on a piecemeal basis. One of those is fraudulent inducement to settle. How do you square that with arbitrating the contract? And also, what about the tortious interference claim? How does that arise out of the settlement agreement?
So I'll turn first to the fraudulent inducement claim. It arises out of the settlement agreement for the following reasons. First, under Texas law, a fraudulent inducement claim cannot exist but for the fraudulently induced contract, and it requires the existence of that contract as part of its proof. Our claim is even more dependent upon the contract because in paragraph 80 of our complaint, we allege that it is misrepresentations in the settlement agreement itself that fraudulently induced us to enter the contract. And I'd also direct the court's attention to the following decisions: Prima Paint, Enri Kaplan from the Texas Supreme Court, Gurwell from a Texas appellate court, Sweet Dreams from the Seventh Circuit, as well as this court's own decision in Marlin, which involve broad and narrow arbitration clauses. And the courts held in all of those cases that fraudulent inducement claims were arbitrable, whether the clause was broad or narrow. As for the tortious interference claim, Your Honor, these claims are specifically predicated on misrepresentations and omissions that we allege appellees made to third parties about the settlement agreement itself. These misrepresentations and omissions are pled at paragraphs 64 and 68 of our complaint, and they are incorporated by reference into our causes of action at paragraph 70. And you'll also find them incorporated by reference into the tortious interference claim at paragraph 117. And so we allege that the breaches of duties imposed by the settlement agreement, the use of our information, the misrepresentation about our relationship, is what caused tortious interference with business relationships. And this court has made clear in numerous cases, as have Texas courts, that a breach of contract can involve tortious conduct that gives rise to both breach of contract and tort claims at the same time. And that's what's happened here. It's why our tortious interference claim arises out of this contract, because it is generated by appellees' alleged breaches of the contract.
Do you have any idea why Judge Hoyt disposed of this in one sentence? I'm looking at the docket. It looks as if there was no oral hearing on the arbitration agreement. So
I do not know. That's quite a mystery to us as well, particularly given the strong presumption in favor of arbitration and the broad language here under numerous court precedents. So his summary denial of arbitration is quite a mystery to us, and it's why we're here. I don't know the answer, unfortunately, Judge. I would like to turn and discuss failure of mediation now. Mediation is a question of procedural arbitrability, and procedural arbitrability is a question for the arbitrator in nearly all circumstances. This court has found that there's only one rare exception in which the court can decide a procedural prerequisite bars arbitration, and that is when it is clearly established that a procedural requirement is a condition precedent to arbitration and has been breached, such that no rational mind could conclude otherwise. That high bar for taking this question of whether mediation is a procedural bar to arbitration has not been, for taking that question from the arbitrator, has not been met in this case, because a rational mind could agree with Polyflow that mediation is not a condition precedent, or that if it is, it's been either deemed fulfilled or excused by appellee's conduct frustrating mediation. And before I tick through those reasons very briefly, I'd like to remind the court that under General Warehouseman and other precedents, this court doesn't need to agree that Polyflow would prevail on any of these points. It need only conclude that a rational mind could agree and that these issues are not clearly established, such that it's the arbitrator's province to decide whether mediation is a bar. Mediation is not a bar, not a condition precedent, because it's disfavored under Texas law. And I note that at page 30 of their brief, appellees have reversed course from their position in the district court, and they've argued to this court that mediation is in fact not a condition precedent. That seems at least suggestive that a rational mind could agree with Polyflow. The settlement agreement's mediation terms only apply to issues of B1 and B2 compliance. They don't apply to the other types of issues that are in dispute here. And even as to B1 and B2, they only apply when the pipe expert has made a determination that the appellees are out of compliance, which appellees concede never happened here. But even if it is a condition precedent, it's been deemed fulfilled by their failure to specifically deny it in their answer. But even more importantly, it's been frustrated by appellees withholding of their design and manufacturing process information, which is the earlier step necessary to even get to mediation. And this court has held that a promissor cannot take advantage of a condition, a failure of a condition that they themselves frustrated. And I see my time is ending, so I will reserve the remaining time for rebuttal.
Thank you, ma'am. We'll hear from Mr. Schlather. You're muted. There you go.
Thank you, Your Honor. May it please the court. My name is Steve Schlather, and I'm representing the appellees here. I think a brief background here will be helpful to understand kind of the context of this settlement agreement. Mr. Wright, one of the defendants and appellees, was the developer of the technology that's kind of at the center of this. He founded Polyflow. He was its CEO for a time, developed its products during that time. At some point, the parties went their separate ways. Mr. Wright set out to form Spclt RTP, where he remains today, and Polyflow continued with its business. You've seen reference, and we discussed it in our brief, that in 2015, Polyflow brought claims against Mr. Wright and SRTP, and in fact, those claims are largely the same claims they bring now in this case. That suit was ultimately resolved. It was really best described as a nuisance suit, and that's evidenced by the fact that if you look at the settlement agreement, no money changed hands there. The heart of that agreement is sections B1 and B2, and those put restrictions on Spclt RTP with regard to what information it can use and what products it could design or manufacture. Mr. Wright and SRTP have never used Polyflow information, but the agreement provided that there was a mechanism for Polyflow to confirm on an ongoing basis whether any of SRTP's products did include
the United States in this honorable
Polyflow
court.
information.
Good afternoon.
Particular importance
Thank you for attending
Spclt
this
RTP
Zoom hearing.
was
I'm very sorry
dispute
that we
resolution
weren't able to
framework set
accommodate you
forth
in New Orleans this week. As
sections
it turns
B4
out,
and
one
B5
panel
of the
of our
agreement.
court is having some
and what
arguments,
those call
but
for is the
since you were
appointment
the
by an
only panel
arbitrator
on which
of
both
what's
attorneys
referred to as
signaled your
an
willingness to
RTP
show up,
expert or a
we
neutral
didn't
pipe
think it made
expert.
sense for us
And
all to
that
troop
was
down there
a
for that
person that
purpose.
was
But things are
neutral and
going to
also
change pretty
knowledgeable
soon,
about
I
the
think.
technology
So
and the
that's
products that
something.
were involved from both
We do have
Polyflow
a
and
couple of
SRTP.
adjustments or
And that framework
extra rules of the
requires that
road
the
for
pipe
purposes
expert
of Zoom hearings. One is
examine
we
any
ask you to
products
silence
that
any other devices
Spclt
you have
RTP
or those of
intended to
people in the room with
manufacture
you.
or design
The second
for
one
a
is
time
that
period and
we
make a determination
still do the
of
audio
whether
recordings
those
of the
products
sitting, but
violated
we will
section
not.
B1 or
we do-
B2
we-
of the
As
settlement
in New
agreement.
Orleans, you're not allowed
And
to
the
video
reason
or
this framework
audio
was set
them
up this
for
way, and the reason
yourselves.
that there was a
If you
neutral
like,
expert put in
we
place
will give
was
you
because
5
Spclt
minutes
RTP was
uninterrupted
particularly
time at the
concerned
beginning of your
that
presentation,
Polyflow would
just
use
because
this
there's always a little
mechanism
bit of a gap in
to
communication here.
to
And
discover
then
or learn
the other
about
thing I would say is
Spclt
we will
RTP's
appreciate in
technology.
both of your
And so
cases
that's why
record
they had this neutral
citations.
expert in between so that
We have a
neither
time clock
party's
system. The yellow light
proprietary
will
information would ever
tell
be
you that you
shared
have 2
with the
minutes
other.
left,
It would
and
all
when the
go
red
to the
light
neutral
signals,
expert. He would
we
make
ask
a
you to
decision,
conclude unless you're
and
answering a question
the
from
information
court.
would remain
The sole
separate
case this
from the other
afternoon
party.
is number 20-20416,
Going
Polyflow
forward,
versus Spclt
the
RTP.
pipe expert,
And we'll
once he
hear
made a
from
decision, and
Mrs.
as Ms. Stratton
to begin.
noted, if the decision
Thank you, Judge
was in
Jones, and may
favor
it please the
of
court.
Spclt RTP,
The parties'
the
contract
pipe
says
expert's
that any
decision was
action
final.
arising out of
Only
the
if
agreement
he
must
found
be
that
arbitrated. In
Spclt
this
RTP was
action,
in
Polyflow
violation,
alleges that appellees
would it then
breached the
trigger
agreement,
a
giving rise to
mediation
various
process,
contract
and
and
the
tort
pipe
claims.
expert would
But
attempt
the
to
district court
mediate that
denied
dispute,
Polyflow's arbitration request.
and only if he was
This court should
unsuccessful in
reverse for
mediating
2
that
reasons.
dispute did the parties then
Because the
agree
parties
to take
undisputably
that
have an
dispute
arbitration
to
agreement,
arbitration?
the law
And that
heavily
is
presumes that Polyflow's
the
action is
arbitration
arbitrable.
provision that you see
To
in
deny
section
arbitration,
B5 of the
this court
agreement.
must have
And it is
positive
specifically related
assurance
to
that the
these
arbitration agreement
disputes
cannot be read to
that
cover
may
this action.
arise in the
There is at
context of
least
the
no
neutral
such
pipe
positive
expert
assurance here.
and sections B1
Second,
and B2
appellees'
of the
merits
agreement.
defenses and
But
procedural
the
arbitrability
important part
challenge
of that
are
is
for the
that
arbitrator to
the
decide,
purpose was
and thus
to
may not
prevent
preclude arbitration.
Spclt RTP's technology
To begin,
from falling
the
into
scope of the
Polyflow's
arbitration
hands
agreement
under
here
the
is
guise of
reasonably
policing the
construed to
agreement.
cover this entire action.
The
The
second
settlement
arbitration
agreement
clause
requires
here
arbitration of
is
any action
found
that
in section
arises out of the
C4.
agreement.
It
The
relates
plain
only
meaning
to
of action is lawsuit,
disputes
the entire
that
civil
arise
proceeding.
under the
So the
agreement.
parties agreed to
And that's very clear.
arbitrate
court-
the
and
entire
I
civil
think,
proceeding if it
on
arises
that
out of the
point,
settlement agreement.
The courts
And
are
this
clear,
lawsuit
including in the
qualifies.
Pennzoil case,
First,
that
this lawsuit exists
an
because of the
arbitration
settlement
clause that
agreement.
uses
And the first
language
page of
such
Polyflow's
as
complaint
arising out of
at 1189
is
of
a
the record
narrow
on
clause,
appeal makes that
and
clear,
the court in
stating
Pennzoil
that Polyflow
contracted
is
that
bringing this
with
action
broad
because the parties
clauses
entered a
that
settlement
use
agreement,
language
but
such
appellees
as
have not
arising
complied
out
with
of
it
or
and
related
never
to.
intended
That's
to
clearly
comply.
not what we have here.
Second, this lawsuit
under
includes claims
Pennzoil,
that
the clause
appellees
in C4
concede
is a
arise
narrow
out of
one.
the agreement. Specifically,
That's further
Polyflow's
evidenced by the fact
claim
that
and
that
appellee's
the clause in
counterclaim
C4
for
does
breach
not
of
even
the
cover
agreement.
all disputes that would
So
arise
because this
under
action
this agreement,
unequivocally
because
includes
it's,
claims
as
that
I
arise out
mentioned,
of the settlement agreement,
the
and
separate
indeed,
dispute
the lawsuit
resolution
only
mechanism
exists
set forth
because there is a
in
settlement agreement
section
that we allege
B5
has been
would
breached,
cover disputes
the action
that
arises out
fall
of the
under
agreement.
sections
And the
B1
plain
or B2
language
of
of the
agreement.
arbitration clause
Well, I
thus
might agree
requires
with you
arbitration
that
of the entire lawsuit.
arbitration provision in
And this court employed that
B5C
reasoning in its
said anything
2019
about
decision
limited to
in
this
Archer,
agreement
which
or
we
this
cited to the court as
mechanism, but
supplemental authority.
it's
The
instead
Archer
it says
panel
for purposes
focused
of
on the
clarity,
plain
the
meaning of the
parties are
term
agreeing
action,
that
which meant
any
the entire
disputes
lawsuit,
arising
not
out
just
of or
individually
related
qualifying
to
claims.
this agreement
And it
will be
refused to
arbitrated.
rewrite the arbitration agreement there to
And
encompass
aren't
only
we,
individually qualifying claims.
since and going
And
a
I
little
think it's
further,
important to note
aren't we
that
required
the
to
reasoning that Archer
interpret
used
these
applies with
provisions
even more
harmoniously
force
and not
in this case, because
one
there
limiting the
Archer
other or
involved
being
an
limited
exclusion from arbitration.
arbitrarily?
So the plain meaning of
as
action,
opposed
the
to the other
exclusionary
one.
language, had to be enough to overcome a presumption in favor of arbitration.
Go ahead.
Here, the plain meaning of any action
Well, I
governs
think
what
they
is
do need to
included in
be
arbitration. So in
interpreted
this case,
harmoniously.
the contract's
I'm sorry,
plain
Your Honor.
language
I think they do
and the
need to be
presumption in
interpreted,
favor of arbitration
harmoniously, and I
are
think the
rowing
way
in the
that
same direction.
that is done in this case
Now,
is that you look
Appellees
at
have contended
you
that the
look at the
settlement
agreement as a
agreement
whole, and
deviates
specifically in
from the
sections
plain meaning of action
B4 and B5,
and
it sets
specially
forth,
defines action to more
this
narrowly
dispute
mean only
resolution
claim.
framework
But the
that
contract
relates
does
to
not support that
as I
argument.
mentioned, the neutral pipe
You can see the
expert
settlement
and
agreement
his
at tab
duties
4
to
of our record
resolve
excerpts. And if you look in
disputes
subsection
arising
A
under
on the very
sections
first
B1
page, you'll
and
see that the
B2.
settlement agreement does not define the term
And then
action.
if you look,
So under
C4
ordinary
then would
contract
cover
interpretation
anything else.
principles,
And
the
so
plain language of the
otherwise
term
you
should govern
would,
lawsuit,
if you
entire
read
civil
section
proceeding.
B5C
What the settlement
broadly
agreement
to
does
cover
define at A1
all
is the
disputes that
term
arise under or
claim.
relate to the
And it
agreement,
defines it because
you
it's
end
going
up
to use that
rendering
term to
C,
describe what is being released
clause in
by the
C4
parties in
a
this
nullity,
settlement
and that's,
agreement and released.
what
So it
the
defines claim
parties intended here
expansively
was that
to include
that agreement
not only
in,
claims, but
or that
also
clause in
demands,
B5 would
actions,
relate
causes
to,
of action, so on and so
the
forth.
dispute resolution.
All that this means,
framework
however,
of
is that
sections
when the
B1
settlement
and
agreement
B2,
uses the
and
word
that C4
claim,
then
it
would
means
cover
to
any other
incorporate a more
disputes
expansive
that
meaning.
arise under the
It does
agreement.
not mean that when the settlement agreement uses the word action, as it does in this arbitration
So
agreement,
with
that
regard
the parties
to
intended to
What's
more
your best
narrowly
case?
constrict the
What's your
plain
best
meaning of
case?
that
With
term
regard
to mean only claim. And
Yeah,
in fact, Your Honors,
you and I,
A1 of the settlement
your
agreement that defines
transmission
claim
is a
shows
little
the parties
slow.
understood
I'm
there is
sorry,
a
I don't
difference
mean to
between the word
interrupt you.
action and the word claim
I
because they
apologize,
define
and
claims to
I
include
don't,
claims, actions,
it
and
does
causes
drop
of action,
occasionally,
showing
and
that
I'm
they
not sure
understand the
why.
difference.
Well,
So we contend, with the
But-
support of Archer and other authorities,
I
that
think
this
just the
any
plain
action
reading
clause is
of
unambiguous,
the
and the entire
agreement,
lawsuit must be
as
arbitrated.
you mentioned, requires
But that is at least a reasonable
those two
interpretation
clauses to
of
be
the arbitration
harmonized,
agreement.
and
And so in that
the
case, the
agreement
standard for
itself
denying
makes
arbitration is not
clear
met
how to
because
do
this
that.
court can have no positive assurance that this
Because
agreement is
it sets
incapable
forth,
of being
it
read
sets
to
forth the
cover this
framework for
action.
dispute resolution under
I'd like to
B1
turn
and
now,
B2
unless the court has
in
questions about the
sections
scope
B4
of
and
the arbitration
B5.
clause, to
As I
appellees'
mentioned,
asserted defenses.
where you have
Let me ask you one question.
two
When you
competing
say
clauses, and in
arbitration
this case, they don't
clause,
compete.
the settlement agreement has two
But
paragraphs
if you did
discussing
try to read them on
arbitration.
top of each other,
You're referring
one would
to
just be rendered a nullity, and that
or C4, or
that shouldn't
how
be the
are we
right
supposed
result
to
here.
interpret those
Further,
provisions together?
I believe I understand
C4
Polyflow
is
to say
the
that
clause
they
that I'm
are
referring to. And Polyflow's position is that,
they
based
are
on the text and context of the
seeking
settlement agreement, that
arbitration solely under
C4 is the
C4
arbitration
in this
clause.
case.
B5C is essentially belt and suspenders. It's additional language that
With
also
regard to
underscores the
the
broad intent of the
argument
parties
that
to
all
arbitrate
claims,
a broad range of disputes. And so when
if
I'm
any
referring to the
claim
arbitration
is
agreement, I'm
arbitrable, all
referring to
claims are
C4,
are
but
arbitrable. And
B5C,
that's,
as we've argued in our brief, is
that's
further
Polyflow's
support
argument
for
with the Archer
the argument
case.
that there's no positive assurance
here
that the parties
again,
agreed to
the agreement
exclude
makes
any of
clear
the claims in this
that
action.
certain disputes, those arising under B1 and B2,
Okay, thanks.
do not fall under
I'll turn
the
now to
arbitration clause
defenses.
in C4.
This court should
And so
hold
at
that
least,
the issues of
one,
release, prior material
category
breach,
of claims
and lack of mediation
would not
are for the arbitrator
go
to
to
decide.
arbitration, even
This
under
court's
that,
inquiry,
or
when
should not
faced
go
with
to
a request for arbitration,
under section
is very
C4.
limited.
That's not what the
The
parties
court does
agreed
not
to.
address the
They
merits,
agreed to have
but
two
asks
separate
only whether an arbitration agreement exists
provisions,
and whether the subject matter
covering
of the
different
dispute
aspects
is
of the
within its
agreement.
scope.
so
And
is,
so
Where the existence
it your
of the
position
contract
that
is
you want
not an
part of
issue,
this,
as here,
uh,
the only defenses a court may
dispute
consider are those that
arbitrated
specifically
and part of
relate
it
to the
submitted
making
to
of the
the federal
arbitration
court?
agreement itself. Defenses
Well,
that
we
apply
believe
to
all
the
the
continuing
claims are
enforcement of the
should properly
contract as a
remain
whole
in
are for
front of
the
the
arbitrator
court,
to
and that
decide
none of them
as
are
part of the
arbitrable.
merits of the underlying
And,
dispute.
well, you just said
This
that
court has held
B1
that
and
repeatedly
B2
in
are arbitrable.
Primerica and Bank One, in
they
Wildrell,
are if
and the Supreme Court has held
that
the
goes
same in
to
Primerica.
whether certain conditions are
Here,
met, and
appellees'
as we
defenses
describe in our
that
briefing,
Polyflow
those
has
conditions just
sued
simply
on
haven't been
released
met.
claims,
There's
or
a
that Polyflow
framework,
has
and
committed a
it
prior material
requires,
breach of the
the
settlement
appointment of an
agreement
MP
by
an arbitrator.
firing the
That
neutral
was
pipe
done.
expert.
And it
These are not
requires the,
independent attacks
pipe
that solely
expert
relate
to
to the
then
arbitration
examine,
agreement, but they are merits
SRTP
defenses that
products
go to the enforcement
if
of the
they,
contract more generally.
are in
And
violation of
appellee's
sections
answer
B1
illustrates
and
that.
B2.
Their answer in
He's
the
done
district
that.
court, which this court can
In
find
this case,
at Record on
he has
Appeal
not found a violation.
1324 to
and therefore,
1325,
under the
and I
under
direct the court
terms of the
specifically to
agreement,
paragraphs
that's
3
the end
and
of that
15,
inquiry.
make it clear
However,
that they have
if
pled
there was
both
a case
release
where he
and
found
prior material breach
SRTP
as
to be in
affirmative
violation,
defenses to Polyflow's
only
claims on the
then,
merits,
if he was not able to
as
mediate
well
that
as
dispute,
using both
would that
release and
specific
prior material
dispute
breach in the
go,
form of allegedly
arbitration
firing the neutral pipe
under
expert
the provision
as a basis for their
Section
counterclaim for breach of
Well,
contract.
I mean, they
So
assert
it's clear
that
from
a
their
number of
answer
their
that
claims.
these issues, release
They
and
assert
prior
in that
material
way,
breach,
then,
these are merits issues for the arbitrator and not defenses to the making of the arbitration agreement for the
Okay.
court.
I'll try again.
Ms.
They
Stratton,
assert
so
that a
let me
number
move
of their
back to the
claims
first
are
issue
based
for a minute.
on
There,
disclosures
there's
of
a
information
argument
in the contrary
arbitration
clauses
Specialty
for
RTP
looking at
this
contrary to
your
the settlement
complaint
agreement
or looking through
interference with
your
causes of action or whatever
customers
on a piecemeal basis.
Polyflow
One of those is
and
fraudulent
inducement to settle.
Lanham Act violations.
How do you square
that with? And it seems to me all of those
arbitrating the
are reasonably
contract?
read
And also,
as
what
being
about the
governed by the
tortious
settlement
interference
agreement. So
claim?
why are
How
they
does
not
that arise
arbitrable
out of
under
the
C4?
settlement agreement?
well, if we
So I'll
look
turn
at the
first to the
at the
fraudulent
Ford case,
inducement
for
claim.
example,
It
the
arises out of the
test
settlement
for whether
agreement for the
tort claims
following
arise
reasons.
or relate
First,
to the
under
relate to
Texas
the
law,
agreement
a
is
fraudulent
whether those
inducement
claims
claim
could stand
cannot
alone.
exist
And so
but for the
certainly
fraudulently
the Lanham
induced
Act
contract,
claims,
and it requires the
which would
existence
relate
of that contract as part of its proof.
trademark trade dress.
Our claim is even
largely,
more
those claims could
dependent
certainly
upon the
stand
contract
alone.
because
Here,
in paragraph
the
80 of our
existence of the
complaint,
agreement
we
is
allege that it is
not required
misrepresentations
to
in
go
the
forward
settlement
with those
agreement
claims.
itself that
With
fraudulently
regard
induced
to
us to
tortious
enter the
interference,
contract. And I'd also
it's the
direct the
same.
court's
The,
attention to the following decisions: Prima
the
Paint, Enri Kaplan from the Texas Supreme
activities
Court,
that
Gerwell
Polyflow
from a
complains
Texas
about
Appellate Court,
which was
Sweet Dreams from the
disclosing
Seventh Circuit,
information to
as well as this court's own decision in
certain
Marlin,
customers,
which involved
setting
broad
aside
and
that-
narrow
that-
arbitration
that
clauses.
may
And,
not
this,
even
and the
fall
courts
under
held
the
in
Lanham
all of
Act
those
because it
cases
doesn't
that
relate to
fraudulent
goods or
inducement claims
services.
were arbitrable, whether the clause was broad or narrow.
Cause of action would stand alone.
As for the
It does not
tortious
require
interference claim, Your
the
Honor,
existence
these
of the
claims are
contract.
specifically
And the same
predicated
is
on
true with
misrepresentations
regard
and
to the
omissions
fraudulent inducement
that we
claims. And
allege
that's,
appellees made to
if we
third
look at the
parties
Ford
about the
case,
settlement
it
agreement
addressed,
itself. These
fraudulent
misrepresentations and
inducement,
omissions
Lanham
are
Act
pled at
claims,
paragraphs
and tortious
64 and
interference claims, and in each
68
of those
of
instances
our
it found
complaint.
that
And they are
they did
incorporated
not
by
relate
reference into our
to
causes of action
the
at
underlying
paragraph
agreement. It
70.
did not require the agreement.
And you'll also find them
and
incorporated by
in
reference
that way
into the
they
tortious
stood
interference
alone,
claim at paragraph
and were not
117.
arbitrable.
And so we allege
I'll
that the
point out in that
breaches
case,
of duties
that
imposed by
was
the
a
settlement
broad,
agreement, the
that
use
did
of our
involve a
information,
broad arbitration,
the misrepresentation
provision
about
that,
our relationship is what
whether any
caused
claims
tortious
arising from
interference
or
with business
related to,
relationships. And this
the
court has made
agreement,
clear
which
in
is
numerous
not what
cases,
we
as
have
have
here.
Texas
We have a
courts,
narrow,
that a breach
provision
of
that only
contract can
covers
involve
claims
tortious
that arise
conduct
from
that
the
gives
agreement.
rise to both
And
breach
so,
of
with
contract
regard to
and tort
Lanham Act,
claims at the same
fraudulent
time.
inducement, tortious
That's what's happened
interference,
here. It's why
they
our
simply
tortious
just don't,
interference claim arises
arise
out
from
of
the
this
agreement.
contract
They-
because it
they
is
stand alone
generated
under
by
Ford.
appellee's alleged breaches of the contract.
Why is it that your
Do you
client
have any,
decided not to do arbitration?
idea why Judge Hoyt disposed of this
in one
Polyflow
sentence,
is asserted
and
in
I'm
this case,
looking at the docket, it looks as
a
if there was
number of
no oral
claims that
hearing
were
on the
that it
arbitration
previously
agreement.
released
So
in the earlier case.
I do not know.
And
That's
we've
quite a mystery
provided
to us as well.
comparison of those claims.
Particularly
You'll see
given the
that
strong
they
presumption in
are,
favor of arbitration and the broad
most of
language
them are
here under
largely
numerous
identical.
court
In
precedents.
fact,
So his summary denial of
the,
arbitration
First Amendment
is
complaint,
quite a mystery to us, and
Polyflow
it's why
makes
we're here.
clear that
I
it's
don't know the
relying
answer,
on
unfortunately, Judge.
activity that occurred before the settlement agreement.
I would
And that's
like
at-
to turn and discuss
record
failure of mediation now.
1203 and 1204.
Mediation is a question
where
of
it sets out,
procedural
it specifically
arbitrability.
sets out
And
before the
procedural
settlement agreement, and
arbitrability
it provides
is a question
kind of
for the
laundry list
arbitrator
of
in nearly all
bad acts that it
circumstances.
claims
This court has
SRTP
found that there's
is
only
guilty
one
of.
rare
And
exception in which
further, in
the
the
court
counts
can decide a
themselves, it
procedural
refers
prerequisite
to,
bars arbitration.
activity
And
involving
that is when it is
Exxon
clearly established that a procedural requirement is a condition precedent to
both of those
arbitration
companies,
and has been breached,
were
such that
part
no
of the,
rational mind could
2015
conclude
laws.
otherwise. That high bar
And
for
so-
taking this question of whether mediation is a procedural bar to arbitration has not been,
we don't want
for taking that question from the
and,
arbitrator, has not
we
been
think
met
they
in
should
this
use-
case. Because a rational mind could agree with Polyflow that mediation is not a condition
they should be
precedent,
resolved,
or that if it is, it's been
in
either
federal
deemed
court,
fulfilled
not in
or
front of an arbitrator.
excused by appellee's conduct
They
frustrating
simply
mediation.
do not
And
arise
before I
out
tick
of
through those reasons very
this
briefly,
agreement.
I'd like to
I mean, if
remind
we
the
look at what
court
the
that under
parties
general
agreed
warehouseman
to
and other
arbitrate,
precedents,
and that's
this court
really
doesn't need to
the
agree
focus
that
here.
Polyflow would prevail on
What
any of
did the
these
parties
points.
agree
It
to
need only
arbitrate?
conclude that a
It's
rational
very clear.
mind
They agreed
could
to
agree and
arbitrate
that these
only
issues are not
those
clearly
disputes that
established,
arise
such
out
that
of
it's
the
the
agreement.
arbitrator's
And
promise
that's
to
it.
decide
The word is
whether
action.
mediation is a bar. Mediation is not a bar,
The
not a
word
condition
is action, and in
precedent
this
because
case,
it's disfavored under Texas law. And I'd note that at
contend
page
action
30 of their
means
brief,
a
appellees have
claim
reversed
or a
course from
cause
their
of
position in the
action.
district court, and they've argued to
And
this
we've
court
addressed the
that
Archer
mediation
case
is in fact not a condition
in our
precedent. That
response
seems
to
at least
Polyflow's,
suggestive that a rational
supplemental
mind could
authority,
agree with Polyflow.
and that's further underscored.
The settlement agreement's mediation
the party's
terms
definition
only apply to issues of
a
B1
claim
and
in this
B2
case,
compliance.
where it
They don't apply to the
defines
other
claims
types of
synonymous
issues
with
that are in
action,
dispute here.
where the parties
And even
wanted
as to
to
B1 and
refer to an
B2, they only
entire
apply when the pipe expert has made a
litigation.
determination
They
that
did
the
so, for
appellees
instance,
are
they
out of
referred to the
compliance,
2015
which appellees concede
litigation.
never happened here. But even if it is a condition
Or they
precedent,
refer to it
it's
as a
been
civil
deemed
action.
fulfilled by their
In this
failure
case,
to
action,
specifically deny it in their answer. But even
should be
more
construed to mean
importantly,
cause of action.
it's
That's
been
further
frustrated
underscored by the fact
by
that
appellees withholding of their
to
design and
read action
manufacturing
as the
process
entire
information,
action
which is
in
the earlier
C4
step necessary to
would
even
then
get to
render any
mediation. And
claims
this
that
court has
arise under
held
B1
that a
and are
promissor
required to
cannot
be
take advantage
arbitrated.
of a condition,
Perhaps at
a
some
failure
point
of a
under
condition
Section
that they
B5,
themselves
it would render
frustrated.
that
And I
a
see my
nullity,
time
and
is ending,
that
so
shouldn't
I will
be,
reserve the remaining time.
the result here.
Thank you, ma'am. We'll hear from Mr. Schlather. You're muted. There you go.
Thank you, Your Honor. May it please the court.
Going
My name
back
is Steve
to,
Schlather, and I'm representing the
two
appellate
issues
here. With regard to the release claims, I
think
understood
a brief background here will be helpful
to
to
argue that that is an issue for the
understand
arbitrator.
the context of
It's
the
simply not.
settlement
In this
agreement.
case, those claims,
Mr.
release
Wright,
claims that
one
are
of
now
the,
included in
defendants and appellees,
Polyflow's current
was the
complaint
developer of
were
the
released in the
technology
same
that's
agreement
at the
that
center of this. He
the
founded
arbitration
Polyflow.
clauses
He was
are
a
found.
CEO for
And
a
so
time.
it developed.
That is
It's
not,
not
during that
Those
time.
claims are not something that
At some point,
the parties
the went their separate ways.
Mr.
Perhaps
Wright
would be a different
set
result
out
if they were
to
form
the release
Spclt
claims
RTP
were in a different
where he remains today,
agreement
or something
and
along those
Polyflow
lines. But
continued
here,
with its business. They were released in the very same agreement. So it makes no sense that the parties would have agreed to release those claims, but still agreed to arbitrate claims against Mr. Wright in the future.
SRTP.
And in fact, those claims
With
are
regard to the
largely the same claims they bring now in this
failure
case.
to mediate.
The framework in
That
section
suit was ultimately
B
resolved. It
is
was
very clear. Really best described as the nuisance suit. And that's evidenced by the fact that
if you look at the settlement agreement,
violation
it can raise that issue.
The heart of that agreement is sections B1 and B2, and those put restrictions on
with his
analysis,
Spclt
RTP
with regard to
resolve the
what
dispute,
information
it can use and what products
SRTP has
design or
complied
manufacture with every request from the
Mr. Wright and SRTP
pipe
have
expert
never
with
used
regard to
Polyflow
providing
information,
products,
but the agreement
provided that
so
there was a mechanism
for examination
for
of
Polyflow
products
to
and
information.
confirm
So to the extent
on an
that
ongoing
Polyflow
basis
claims
whether
that
there are
any
products
of that
SRTP's
it believes
products
are involved
did include
violation, but
Polyflow
SRTP is
information
not turned over.
of
That is the results to the Polyflow
the
not
RTP
raising that issue
was
with the neutral pipe expert
dispute
resolution
resolution
framework set forth in sections B4 and B5 of the agreement. And what those call for
Yes, sir, you're
is
out
the
of time.
appointment
We'll
by an
go back to
arbitrator
Ms. Stratton
of
for
what's
rebuttal.
referred to as an
Thank you, Your
RTP expert or a
I'd
neutral
like to
pipe
begin
expert.
with the issue of mediation.
And that
You've
was
heard
a
opposing counsel
person that
describe
was
their view of why
neutral and
mediation was a
also
prerequisite
knowledgeable
here.
about the
And we
technology
obviously
and the
vehemently
products that
dispute
were
that, and
involved
that's precisely
from both
why
Polyflow
the
and
issue is not
SRTP.
clearly established
that
such that this
framework
court could
requires
decide it
that
because
the
no rational
pipe
mind could
expert
do anything but agree with with Mr.
examine any
Schlather's position.
products
He's
that
not articulated why
Spclt
it is clearly
RTP
established and
intended
essentially
to
undisputed here
manufacture
that a
or
procedural
design
prerequisite
for
was
a time
breached.
period
So all of
and
his
make a
arguments about
determination
what
of
should have been
whether
done in the mediation
those
process,
products
that's all for the
violated
arbitrator to
Section
decide
B1 or
under this court's
B2 of the
procedural
settlement
arbitrability
agreement.
precedents.
And the reason
I'd
this
like to
framework was
also
set up
briefly
this way, and the
discuss the
reason
issue
that
of
there was a
release.
neutral
Appellees appear to
expert
be
put in
trying to
place
take the
was
issue of
because
release and frame it
Spclt
as a
RTP
question
was
of what the
particularly
parties
concerned
agreed to
that
arbitrate, a question
Polyflow
of
would
substantive
use
arbitrability.
this
But this
mechanism
court has made
to
clear that it does not consider the merit
to
in its
discover or
substantive
learn about
arbitrability determination.
Spclt
You said that in
RTP's
Chevron Chemical,
technology.
you said it in Bank One
And so
Depot,
that's
and in
why they
numerous other
have this
cases.
neutral expert
And
in
what
between
Mr.
so
Schlather's
that
argument
neither
does by asserting
party's
release as a question of the
proprietary
scope of
information
the
would ever
arbitration
be
agreement
shared with
is
the other.
inject
It would
the
all go
merits
to the neutral
into the
expert, and he
substantive
would make a
arbitrability
decision,
determination. For this court to decide whether
the
Polyflow
information would
released or sued on
remain
released claims,
separate
it would
from
have
the
to
other
resolve
party.
the merit. That is a basis for Polyflow's counterclaim in this
Going
case.
forward,
That's not properly before the court in a
the type
substantive
expert, once he made a
arbitrability
decision,
analysis.
as Ms.
Release
Stratton
is a
noted,
defense.
if
That's
the
how this court
decision
should treat it, and
was
that's
in
exactly
favor
how
of Spclt
Mr. Schlather's
RTP,
answer on
the
behalf of Spclt
type
RTP
expert's
in the district
decision
court
was final.
treated it
Only
as an
if
affirmative defense
he
on the merits,
found
a
that
basis for their merits
Spclt
counterclaim, and
RTP
therefore
was in
it's properly
violation,
submitted to the arbitrator
would
as part of
then
the underlying
trigger
merits of the
a
dispute.
mediation process.
Now,
and
I'd
the
like to
type
move
expert
on
would
to
attempt to
addressing
mediate
the
that
interaction
dispute.
between C4
And
and B5.
only if he was
There is a way
unsuccessful in
to
mediating
harmonize
that
these
dispute
provisions, to
would the
read
party,
them
did the
quite
parties then
naturally
agree
in a way
to
that doesn't
take
treat them
that
as two separate
dispute
arbitration
to
provisions or
arbitration?
treat them
And that is
as
the
a limitation on one
arbitration
another.
provision that
First,
you see
there
in
is nothing in the
section
text
B5
of
of the
either
agreement.
C4 or
It is specifically
B5C
related
that suggests
to
that they apply to
these
anything
disputes
other than the
that
entirety
may
of the
arise in the
agreement. There is
context
no
of the
limiting
neutral
language,
pipe
as Judge
expert and
Jones
sections
noted.
B1 and
And the most
B2
natural
of the
reading we
agreement.
submit of
But
B5 is that it is
the
inserted
important
to
part of that
protect the
is
breadth
that
of the parties'
the purpose
arbitration
was
agreement.
to
Because it
prevent
appears in a section
Spclt
laying out certain
RTP's technology from
procedures
falling into
for
Polyflow's hands
resolving
under the guise of
certain types of
policing the
disputes under
agreement.
the agreement. And it heads
The
off
second
the
arbitration
potential argument
clause
that by
here
laying out those
is,
procedures, these were
found
the
in section
only
C4.
substantive claims the
It
parties
relates
intended to
only
arbitrate.
to
And so the text of B5
disputes
says
that
very clearly,
arise under
for
the
purposes
agreement.
of clarity, we are
And
clarifying
that's very
that
clear
we
to
are
the court.
agreeing
And-
that
and I
any
think,
dispute
on
arising
that
out of or
point,
related to this agreement
the
shall be
courts are clear,
arbitrated.
including in the
And so
Pennzoil case,
in C4, you
that
have an extraordinarily broad arbitration
an
provision.
arbitration clause
In
that uses
B5C,
language
you have
such
another
as arising
extraordinarily
out
broad
of
arbitration provision. And
is a
broad plus
narrow
broad
clause.
equals
And
broad.
the
It does
court in
not, as Mr.
Pennzoil
Schlather
contrasted
contends,
that
equal narrow.
with broad
And it does not equal
clauses
arising
that use
under, which is what he
language
said at the beginning
such
of the
as
argument, that we
arising out
agreed in
of or related
C4 to arbitrate
That's clearly not
arising
what we have
under.
here.
This court made clear in
Under
Expo that arising
Pennzoil,
out
the
of and
clause in
arising
C4
under are not the
is a
same.
narrow one.
And that arising out of is a
That's
broader
further evidenced
arbitration
by the fact
clause
that
than the more narrow
the
arising
clause in
under.
C4 does
It's
not
Mr.
even cover
Schlather's
all
burden to
disputes that
furnish
would
this court
arise
with positive
under this
assurance
agreement.
that these
because
this
as I
arbitration
mentioned,
agreement cannot be read to cover this
separate
action.
dispute resolution
And in order to
mechanism
meet
set
that
forth
burden,
in
appellees have had to
section
rewrite the
B5
arbitration
would
language
cover
to arising
disputes
under
that
and call
fall under
arbitration clauses
sections
that
B1
this
or
court
B2
and
of
others
the
have
agreement.
repeatedly called
Well,
broad,
I might agree
narrow,
with you
insisting
if the
upon that. And our
arbitration
opinion,
provision
Your Honors, is that doesn't amount to positive assurance that these claims are not arbitrable. I'd also like to briefly distinguish Ford, which Mr. Schlather relies
instead
upon.
it says for
In Ford,
purposes
the
of
court
clarity,
made it
the
clear
parties are
that when
agreeing
a tort
that
claim
any
is based upon a breach
dispute
of
arising
contract,
out of
it's
or
arbitrable.
related to this agreement
There was
will
no
be
breach of contract
arbitrable.
claim in the case. The parties could have
And,
completely
is
complied with their
are we-
obligations under the
since-
contract, and the tort
And
claim in
going a
that
little
case
further,
would still have proceeded.
aren't we
That's why the Ford
required
court was
to
able to say this
interpret
contract is
these
legally irrelevant to this
provisions
tort claim. We can treat it
harmoniously
like
and
it
not,
doesn't exist. That's
one
not possible
limiting the
here.
other or
For
being
example, Mr.
limited
Schlather asserts that the Lanham Act
arbitrarily,
claims have nothing to do
as
with the settlement
opposed to the
agreement, but
other
I'd
one.
refer the court to paragraphs 96 and 114 of our unfair competition
Go
claims,
ahead.
which are based specifically upon
Well, I think they do
appellees'
need to be
misrepresentations about the
interpreted
terms and scope of the
harmoniously.
settlement agreement itself.
I'm sorry, Your Honor.
The
I
fact
think
finder
they do
simply
need to
could
be
not resolve
interpreted,
those claims without
harmoniously.
consulting
And I
the
think
terms
the
and
way
scope of the
that
settlement agreement, and they
that is
arise
done in this
out
case
of
is
the
that you you look
contract.
at,
Thank you.
you look at the agreement as a
All
whole.
right, thank you very
and
much.
specifically in
That
sections
concludes our
B4 and B5, it
brief
sets forth
hearing for today,
this
and we'll
dispute
take the case under
resolution
advisement.
framework
Thank
that
you.
relates to as I mentioned, the neutral pipe expert and his duties to resolve disputes arising under sections B1 and B2. And then if you look, C4 then would cover anything else. And so otherwise you would, if you read section B5C broadly to cover all disputes that arise under or relate to the agreement, you end up rendering the clause in C4 a nullity. And that's what the parties intended here was that agreement or that clause in B5 would relate to the dispute resolution framework of sections B1 and B2, and that C4 then would cover any other disputes that arise under the agreement.
Well,
so with regard to
what's your best case? What's your best case?
With regard to
Yeah, you and I, your transmission is a little slow. I'm sorry, I don't mean to interrupt you.
I apologize, and I don't. It does drop occasionally, and I'm not sure why.
Well,
I think just the plain reading of the agreement, as you mentioned, requires those two clauses to be harmonized, and the agreement itself makes clear how to do that, because it sets forth the framework for dispute resolution under B1 and B2 in sections B4 and B5. As I mentioned, where you have two competing clauses, and in this case they don't compete. But if you did try to read them on top of each other, one would just be rendered a nullity, and that shouldn't be the right result here. Further, I believe I understood Polyflow to say that they are seeking arbitration solely under C4 in this case. With regard to the argument that all claims, if any claim is arbitrable, all claims are arbitrable, and that's Polyflow's argument with the Archer case. Here again, the agreement makes clear that certain disputes, those arising under B1 and B2, do not fall under the arbitration clause in C4. And so at least one category of claims would not go to arbitration, even under that, or should not go to arbitration under section C4. That's not what the parties agreed to. They agreed to have two separate arbitration provisions covering different aspects of the agreement.
So is it your position that you want part of this dispute arbitrated and part of it submitted to the federal court?
Well, we believe all the claims should properly remain in front of the court, and that none of them are arbitrable. And
well, you just said that B1 and B2 are arbitrable.
They are if, and that goes to whether certain conditions are met. And as we describe in our briefing, those conditions just simply haven't been met. There's a framework, and it requires the appointment of an MPE by an arbitrator. That was done. And it requires the pipe expert to then examine SRTP products to see if they are in violation of sections B1 or B2. He's done that. In this case, he has not found a violation, and therefore, under the terms of the agreement, that's the end of that inquiry. However, if there was a case where he found SRTP to be in violation, only then, if he was not able to mediate that dispute, would that specific dispute go to arbitration under the provision in section B5.
Well, I mean, they assert that a number of their claims,
So, in that way, then.
Okay, I'll try again. They assert that a number of their claims are based on disclosures of information contrary by Spclt RTP, contrary to the settlement agreement, interference with customers of Polyflow, and Lanham Act violations. And it seems to me all of those are reasonably read as being governed by the settlement agreement. So why are they not arbitrable under C4?
Well, if we look at the Ford case, for example, the test for whether tort claims arise or relate to the agreement is whether those claims could stand alone. And so certainly the Lanham Act claims, which relate to trademark trade dress largely, those claims could certainly stand alone here. The existence of the agreement is not required to go forward with those claims. With regard to tortious interference, it's the same. The activities that Polyflow complains about which was disclosing information to certain customers, setting aside that may not even fall under the Lanham Act because it doesn't relate to goods or services. That cause of action would stand alone. It does not require the existence of the contract. And the same is true with regard to the fraudulent inducement claims. And that's, if we look at the Ford case, it addressed fraudulent inducement, Lanham Act claims, and tortious interference claims. And in each of those instances, it found that they did not relate to the underlying agreement and did not require the agreement. And in that way, they stood alone and were not arbitrable. And I will point out in that case that was a broad that did involve a broad arbitration provision that covered any claims arising from or related to the agreement, which is not what we have here. We have a narrow provision that only covers claims that arise from the agreement. And so with regard to Lanham Act, fraudulent inducement, tortious interference, they simply just don't arise from the agreement. They stand alone under Ford.
Why is it that your client decided not to do arbitration?
Polyflow has asserted in this case a number of claims that it previously released in the earlier case. And we've provided a comparison of those claims, and you'll see that they are, most of them are largely identical. And in fact, in the first amended complaint, Polyflow makes clear that it's relying on activity that occurred before the settlement agreement, and that's at record 1203 and 1204. Where it specifically sets out before the settlement agreement, and then provides a kind of laundry list of bad acts that it claims SRTP is guilty of. Further, in the counts themselves, it refers to activity involving Exxon, Petronas. Both of those companies were part of the 2015 lawsuit. And so we don't want a case, and we think they should they should be resolved in federal court, not in front of an arbitrator. They simply do not arise out of this agreement. I mean, if we look at what the parties agreed to arbitrate, and that's really the focus here, what did the parties agree to arbitrate? It's very clear. They agreed to arbitrate only those disputes that arise out of the agreement.
And that's it. The word is action.
the word is action, and in this case, we contend that action means a claim or a cause of action. And we have addressed the Archer case in our response to Polyflow's supplemental authority, and that's further underscored by the party's definition of a claim in this case, where it defines claim synonymous with action, where the parties wanted to refer to an entire litigation. They did so. For instance, they referred to the 2015 litigation, or they refer to it as a civil action. In this case, action should be construed to mean cause of action, and that's further underscored by the fact that to read action as the entire action in C4 would then render any claims that arise under B1 and are required to be arbitrated, perhaps at some point under Section B5, it would render that a nullity, and that shouldn't be the result here. Going back to two issues, with regard to the release claims, I understood Polyflow to argue that is an issue for the arbitrator. It's simply not. In this case, those claims, the released claims that are now included in Polyflow's current complaint were released in the same agreement that the arbitration clauses are found. And so that is not, those claims are not something that the parties agreed to mediate. It perhaps could be a different result if the release claims were in a different agreement or something along those lines. But here they were released in the very same agreement. So it makes no sense that the parties would have agreed to release those claims, but still agreed to arbitrate them at some point in the future. With regard to the failure to mediate, the framework in Section B is very clear that if Polyflow believes that SRTP is in violation, it can raise that issue with the neutral pipe expert, and then he will go forward with his analysis and mediation if necessary to resolve the dispute. SRTP has complied with every request from the pipe expert with regard to providing products. So for examination, products and information. So to the extent that Polyflow claims that there are products that it believes are in violation, but SRTP has not turned over, that is the result of Polyflow not raising that issue with the neutral pipe expert in the first instance. And I see I am out of time.
Yes, sir, you're out of time. We'll go back to Ms. Stratton for rebuttal.
Thank you, Your Honor. I'd like to begin with the issue of mediation. You've heard opposing counsel describe their view of why mediation was a prerequisite here, and we obviously vehemently dispute that. And that's precisely why the issue is not clearly established such that this court could decide it, because no rational mind could do anything but agree with Mr. Schlather's position. He's not articulated why it is clearly established and essentially undisputed here that a procedural prerequisite was breached. So all of his arguments about what should have been done in the mediation process, that's all for the arbitrator to decide under this court's procedural arbitrability precedents. I'd like to also briefly discuss the issue of release. Appellees appear to be trying to take the issue of release and frame it as a question of what the parties agreed to arbitrate, a question of substantive arbitrability. But this court has made clear that it does not consider the merits in its substantive arbitrability determination. You said that in Chevron Chemical, you said it in Bank One v. Hill, and in numerous other cases. And what Mr. Schlather's argument does by asserting release as a question of the scope of the arbitration agreement is inject the merits into the substantive arbitrability determination. For this court to decide whether Polyflow released or sued on released claims, it would have to resolve the merit. That is a basis for Polyflow's counterclaim in this case. That's not properly before the court in a substantive arbitrability analysis. Release is a defense. That's how this court should treat it. And that's exactly how Mr. Schlather's answer on behalf of Spclt RTP in the district court treated it, as an affirmative defense on the merits, a basis for their merits counterclaim, and therefore it's properly submitted to the arbitrator as part of the underlying merits of the dispute. Now, I'd like to move on to addressing the interaction between C4 and B5. There is a way to harmonize these provisions, to read them quite naturally in a way that doesn't treat them as two separate arbitration provisions or treat them as a limitation on one another. First, there is nothing in the text of either C4 or B5C that suggests that they apply to anything other than the entirety of the agreement. There is no limiting language, as Judge Jones noted. And the most natural reading we submit of B5 is that it is inserted to protect the breadth of the parties' arbitration agreement, because it appears in a section laying out certain procedures for resolving certain types of disputes under the agreement. And it heads off the potential argument that by laying out those procedures, these were the only substantive claims the parties intended to arbitrate. And so the text of B5 says very clearly, for purposes of clarity, we are clarifying that we are agreeing that any dispute arising out of or related to this agreement shall be arbitrated. And so in C4, you have an extraordinarily broad arbitration provision. In B5C, you have another extraordinarily broad arbitration provision, and broad plus broad equals broad. It does not, as Mr. Schlather contends, equal narrow, and it does not equal arising under, which is what he said at the beginning of the argument, that we agreed in C4 to arbitrate arising under. This court made clear in Explo that arising out of and arising under are not the same, and that arising out of is a broader arbitration clause than the more narrow arising under. It's Mr. Schlather's burden to furnish this court with positive assurance that this arbitration agreement cannot be read to cover this action. And in order to meet that burden, appellees have had to rewrite the arbitration language to arising under and call arbitration clauses that this court and others have repeatedly called broad narrow, insisting upon that. And in our opinion, Your Honors, is that doesn't amount to positive assurance that these claims are not arbitrable. I'd also like to briefly distinguish Ford, which Mr. Schlather relies upon. In Ford, the court made it clear that when a tort claim is based upon a breach of contract, it's arbitrable. There was no breach of contract claim in the case. The parties could have completely complied with their obligations under the contract, and the tort claim in that case would still have proceeded. That's why the Ford court was able to say, this contract is legally irrelevant to this tort claim. We can treat it like it doesn't exist. That's not possible here. For example, Mr. Schlather asserts that the Lanham Act claims have nothing to do with the settlement agreement, but I'd refer the court to paragraphs 96 and 114 of our unfair competition claims, which are based specifically upon appellees' misrepresentations about the terms and scope of the settlement agreement itself. The fact finder simply could not resolve those claims without consulting the terms and scope of the settlement agreement, and they arise out of the contract. Thank you.
All right, thank you very much. That concludes our brief hearing for today, and we'll take the case under advisement.
Thank you.